As is as reflected on Exhibit 15 and discussed in Mr. Ellison's declaration, the average weighted fee royalty to be imposed today is 19.03115534%. Excuse me. And with that, I will move on to
Oh, sure. I'm a senior land negotiator with, I don't know, purview over this DSU along with others in the basin.
okay. The hearing examiner started asking a couple questions that I think were really important. I'm going to go through those again for you. You're aware of the declaration or the, excuse me, are you aware of the declaration that's been filed on your behalf titled Declaration of Ashley Ellison?
I am, sir.
Okay. And have you reviewed the allegations contained in that declaration?
I have.
Okay. Did you execute the declaration or cause your counsel to execute on your behalf?
Yes, sir.
Okay. And does the declaration match your testimony here today? Is there anything you'd like to add to flesh out that?
It matches. I have nothing more to add.
Okay, thank you. With that, I think it's appropriate to turn him over for any questions, or we can do the reservoir engineer and ask generally.
Let's take it one at a time.
Okay.
Sure. I'd like to throw over to division for any questions you may have for this witness.
Thank you. Reviewed the declaration. I don't have any substantive questions, just more inquiry. I'm just curious about Catherine Hodgkin. She just took a longer time to get back to you guys. How did that come about?
Yeah, I'm happy to answer that. We actively try to find individuals throughout the lifetime of the initial drill and then even afterwards. A lot of times people receive mail and then it's just hard to get a hold of people. In this instance, once you start getting more mail with these forced pooling hearings, and it's a lot of times it kind of shakes out some of the people that haven't been responsive in the past, which is a benefit for everybody. So in this case, Ms. Hodgkin did reach out to us once she started receiving these forced pooling notifications and was happy to lease, which is at the end of the day what OVINTIV would prefer as well. Forced poolings are always kind of a last-ditch effort for us when we can't find people or we can't get anybody to get to call us back, I guess.
Thank you. Yeah. Another question by the division.
I want to go over this list of individuals that have been pulled. Obviously, Catherine Hodgkin was located and signed on. The other three here, Glenn Decker, Mary Ellen Slamaker, they were locatable but refused to respond.
That's right. My understanding. Oh, sorry, Ash, go ahead.
No, go for it. That is correct. Is all I was
just going to say, yeah, Miss Slamaker Benyon and Miss Tracy Lee Morgan come from the same kind of family lineage, and they've been pooled repeatedly. But OVINTIV is fairly confident those are the correct addresses for those two. I don't know much about Glenn Decker specifically. Ash, if there's anything to add.
I do not know any additional information from Glenn Decker. I do know that a lot of time the other two individuals, there are instances where people just don't want anything to do with oil and gas. So as Mitch mentioned, these individuals, we we talk with occasionally, and they simply don't want to lease or don't want to do anything with it, I guess.
So to put these in two categories, you could say they could call back or write back and say, just leave us alone.
Sure, exactly.
Or they just refuse to say anything.
That is
In that
correct.
case, you're still locatable, but non-participating.
That is correct.
And it is a judgment call at some extent between counsel and client as to whether they're unlocatable. You send something to someone you're really confident is their address, but it comes back undeliverable. What do you do? And usually in that situation, publish notice in addition to, in this case, just being honest.
And then the loan unlocatable is Tracy Lee Markham Cheryl. So that's just, it came back and you really have no knowledge of what's going on there.
I mean,
Yep.
Okay. But I just want to get that straight because I saw this list here and was understand it. Now let's move on to the deceased parties, okay? So these are individuals that have the mineral lease in their name, and they obviously have passed away and have a lineage or heirs that you are trying to find. It could, and you just don't know who they are.
one correction. If they had a mineral lease, they wouldn't be on the list. They have a mineral interest.
Interest, okay, that's what I meant. Sorry. Okay, so in that case, you don't know who all these people are. If they did, if someone responded that said, I am related to C. Ed Flandreau, is that something that OVINTIV needs to prove, or do you just simply put the pooling in the name of the individual?
Well, I mean, if you're talking from an OVINTIV perspective or from kind of a how do we do this perspective, it's either the ask or we answer, depending on kind of where you work.
Well, I just want to understand how these deceased parties are handled, because we get so many of them.
Well, what I'll say from my perspective, and Ash, you can fill in as you feel necessary to compliment or change what I say. But the truth is, anytime someone contacts us during or even after, we follow up. The truth of the matter is, most of those contacts are, my grandpa's cousin was Ed Flandreau, and my grandpa's brother is dead, but his sister, I think, lives in Philadelphia. I'm not sure who Ed Flandreau's relatives are. And so we get these contacts that are helpful, but not necessarily solid. The other alternative is you get a call and they'll say, hey, I'm Ed Flandreau's grandkid. What's happening? I'm leased. I've already leased my interest. Is it being taken? It's an explanation. Listen, if you've leased, you're not covered. This is pooling anyone who isn't leased and inherits it. The third option is they call and say, I'm Ed Flandreau's daughter. He died 20 years ago. And we say, okay, well, you have to probate his estate because we don't know for sure. That's it. And they say, well, I can't get to that, or I'm not interested in that, or that will be 2 months, or I'll get back to you. And then we do. So anyone who approaches and has any information that helps us, as Ash said, I don't think OVINTIV is alone. Most operators do look at forced pooling as a last resort. So if anyone contacts and says, I have information as to potential owners in your unit, they're going to do everything they can to try and follow that. It just usually ends up at the same dead end that it started with, unless someone from that vintage is ready to kind of take forward and cure the issues.
And that takes a probate.
Generally a probate or finding old documents or talking to distant family members and getting them to lease. And, there's just some complications that a lot of people don't, especially in 20 days turn. And like, yeah, I'll deal with that later. And just
So then, okay, go ahead, Ashley.
Yeah, I'm sorry. I'm happy to expound on that. And I talked to an individual yesterday with an older gentleman that his grandfather's estate had not been probated. His grandfather had 6 children, and now those 6 children have 20 to 30 individuals. So there's 50 individuals associated with this one grandfather now, let's say. And I don't know the specifics. I'm just talking about generally for this estate, just trying to give us a concrete thing to discuss. We, OVINTIV and our brokers have gone through and tried our hardest to figure out the heirs of all of these estates. And our goal is to lease all of these estates. So if these individuals ever probate the estate and have clear title into their name, we are able to pay royalties. So in the forced pooling instance, all of these estates, we have done our best to figure out who we think the heirs are. We just don't know 100% that that is completely correct. Once you go through probate, some person might interject that grandfather had a stepson that we didn't know about, and then somebody else comes out that we have not leased. And those individuals, in the rare case that might bubble up, it's my understanding that these individuals would then receive the forced pooled interest. And we do that simply because we have to set something up. And we can't wait until people probate estates to know definitively, because a lot of the time, nobody really wants to deal with it because they don't necessarily have to. It just kind of sits there until maybe somebody probates an estate in the future, I guess.
Well, yeah, and I think to further complicate it, in this example, Ash brings up, Grandpa may have owned 2 mineral acres in this drilling unit, and now that 2 mineral acres is divided among 50 people in their degrees. And so when you go to them and say, hey, we can pay you, but you have to probate Grandpa's estate so everyone has it. It's like, well, my check is going to be $75. Why would I spend $1,500 to get it? And so you get that kind of issue bubbling up often, where it just gets fractionated. It's hard to get people correctly. So it doesn't make sense.
So for clarification, to be conservative, you foretold the deceased party, not knowing exactly what's happened from the death to the present. And
That's
if you did to force pull someone and it was wrong, then you would have liability. So to be conservative, you just go back to the deceased party.
That's right. And technically speaking, upon death in Utah, title vests in your heirs.
Mhm.
So we're not really pooling the deceased party. They're the record interest owner.
Yeah.
And we don't know who their heirs are. So there's kind of an equitable title, marketable title issue going on. But yeah, our job is to go into calls and says, hey, Mitch, I've got this estate. What do we do? We look at the probate laws that were in effect in 1972 when he died. Well, his wife should get this percent, probably, unless he had an ex-wife, unless this. So there's caveats in every step of the analysis. And when you get to the end, you have to say, yeah, but we have to be conservative to make sure to get it.
Okay.
This game got this.
Sorry to go over that, but I think I've done enough of it because it's still very, very cheesy at times.
No, I think it's a really helpful discussion.
Okay, well, thank you. Now we noted here that the first production was January 22nd of 2019. Why so long between that point in time to where you wanted to do a compulsory pooling order?
Oh, I think generally at that time, I think we were simply understaffed, and just had other, I think they had 2 or 3 rigs running at that instance. So we're now going back and just trying to figure out what to do with the last tiny interest on these decks. They're presently set up as just unleased, and it's just kind of waiting to figure it out, I guess. And now we just have we dropped our rig for the last 6 months. We'll pick it up again, but we just have the time at the moment to do some of these, and that's why we're doing them now, I guess.
Okay. So the next question is, so from the original production till now, those dollars, those royalty dollars, where do they sit currently?
Yeah, it all goes in suspense. Go ahead, Mitch, if you were going to say something.
No, I was pointing at you. I thought you'd knock it out of the park.
Yeah, I mean, OVINTIV does not use any money that we don't know where it's supposed to go. It simply sits in a suspense account. And a lot of times I will work with heirs who are thinking about probating their estate. And the first question that they ask is, how much do I have in suspense? Because that determines if they might want to pay an attorney to help them fix their issues. So it just sits there. And then I think after a while it escheats to the state. Escheat is a hard word to say. But and Mitch, you might know more about that than I do, but OVINTIV does not capture any royalties that are due to anybody. It just sits in the suspense until they fix their issues, I guess.
That's right. And until the acreage weighted royalties imposed at this hearing, there really isn't even a royalty that could be imposed. So I think it's just 100% of their interest, I would imagine, it's suspended until you kind of sort this out.
That's correct.
Then you can take that and break it up among, royalty.
So it's in a suspense account, but each individual mineral owner has their piece of it.
Yeah, that's correct.
But it's still a guess at this time because you don't know a royalty.
Yeah, that's 100% correct. I told a guy earlier today or yesterday that he has $2,000 in as an account for a very number of wells. He has a very small interest. But at the end of the day, it could come out that he has a brother that he knew nothing about, and if we had paid that to him, that nobody is paying us back half of those royalties in the future. It's hard to get money back from individuals. So that's why we wait until he has clear title from a probate and then necessary personal representative's deeds into himself, where we'll pay those royalties at that time. So we're not left holding the bag, so to speak, I guess.
Now, I know in Utah, I think it's 5 years. Once you hold that money 5 years, it goes to unclaimed property.
That's my understanding too. 5%.
So if that money goes to unclaimed property, because what's this was drilled in 2019, I mean, we're almost 5 years out.
Sure.
Is it necessary for you to pool this? I guess you'll keep collecting dollars in there. You'll just put the first 5 years in, and then you'll keep going until you. So you got to get it cleared up eventually.
Yeah, that's great.
And the truth of the matter is, Mr. Hearing Examiner, when we're done with this pooling, all we have is accurate numbers to put into pay tags. But a lot of these people still will never come forward, and so their suspense proceeds will continue to grow, and they will eventually all exchange for a lot of these, the folks who are unlocatable estates from the 50s and 60s.
Okay. A lot of work. Okay, I'm sorry to beat that to death. I won't do it for the next one because they're similar questions, but I understand this better, and I think it's good to go on record.
No, I think they're good questions. At the end of the day, OVINTIV, myself, would love if everybody had clear title and then we knew exactly 100% who to pay, and who to lease, and then it would just be easier. And unfortunately, we're just doing the best we can with the situation it is.
Well, I noticed here, I can't remember where, I can't find it off the top, but the percentage of the whole is small. It's less than 1% or 0.5%.
Oh yeah, it's 0.36% is what we're outstanding that we're trying to pool, I guess.
Well, that's all the questions I have for Mr. Ellison.
Okay, perfect. Stick around for a minute. We may call you back, but I'm going to switch to Chris for a second. You can put yourself on mute if you want.
Very good, thank you.
Chris, can you hear me okay?
Yes, sir.
Okay. Same thing we did for Ash. Can you just state your name and business address for the record and spell your last name, please?
Sure. My name is Christopher Wall. I go by Chris. Last name's W-O-L-L. Business address is 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas, 77380.
Okay. And can you please remind everyone your job title with OVINTIV and your responsibilities as they relate to this unit?
Yes, I'm a senior reservoir engineer, and I have jurisdiction over this DSU as well as others in the Uinta Basin.
Okay. Thank you for that. I'd like to remind everyone that Mr. Wall's testimony is offered as expert testimony in petroleum engineering. Mr. Wall, can you confirm your declaration testimony for me? Are you familiar with the declaration of Christopher Wall that was filed in this cause?
Yes.
Have you, did you execute that or cause your counsel to execute it on your behalf?
Yes,
And are you familiar with each of the allegations therein?
I am. Yes.
Does the declaration match your full testimony here today? And or if not, is there anything you'd like to add?
It is accurate for today. Yes.
Okay. Thank you. That was a tough compound question. In your expert opinion, Mr. Wall, were the actual costs as reflected in Exhibit 16 fair, reasonable, and necessarily incurred and within a reasonable variance of the AFE costs?
Yes.
And do the risks present in the Knoll DSU justify the 300% risk compensation award requested in your expert opinion?
Yes.
With that, I'm happy to turn them over to division hearing examiner.
Division? Well, I just had a question in Exhibit 18. We talk about the drilling operation challenges. It says that set production casings 475 feet short of TD due to hole conditions. Is that I think I've seen that a couple or similar things. Is that a problem that's been occurring in this area? I mean, that doesn't seem to be that it was unique just to this well. Would that be correct?
Yeah, that is correct. I mean, this is a problem that we've had on other wells, and I think other operators may have this challenge as well. I think it just really shows and speaks to the, some of the challenges that we have in the various formations that we drill in the Uinta Basin. Sometimes we can't execute as flawlessly as we'd hope.
Thank you. I have no further questions.
Thank you. Back along those lines, I did have a question about that length, that 475. It said short of TD, total depth. Are we looking at the toe of this or the vertical where you had the problems?
It's at the toe. So we drilled to our total depth, and that would be at the very end of the well, the toe of the well. And we weren't able to set the casing all the way there, which if we do, for example, 240-foot completions stages, that's roughly 2 stages that we can't get away in that well. So setting the pipe short doesn't allow us to get everything that we want out of the wellbore.
So you're being shorted that amount for production. That's right at the end. Okay. Also, you mentioned that your P&A cost is $75,000. I'm seeing that kind of the common estimate. I don't think any of these wells have actually been plugged, these long horizontals. So, or do you have any feel for how accurate that number is, or is that just a ballpark right now?
Well, I think it's based primarily on us plugging some of the vertical wells. And so while it's an estimate, it is based on some of the recent P&A work that we do in the field. But you are correct. We have not plugged any horizontals that I know of to date.
Does a horizontal add much more cost to plugging a well?
The only thing that it might add is extra cost pulling some of the casing that we want out, but I don't think, I just wouldn't be able to tell you exactly how much it would add, if any.
I've gone over a few of some other pulling matters, and some of the long horizontals have been estimated up to 150,000. So I'm kind of concerned about, I mean, I'm not saying who's right or wrong, but if it's just where that's at.
Well, and the truth is, from my understanding, the pooling orders, grant you recovery of the costs to plug and abandon a well, whatever they may be. I think these are estimated costs, so the parties have numbers to work with in the 30 years into it.
Okay. The other thing I'm seeing is the 300% is kind of a generic number. Can you explain to me where you came up with that number, or what would cause that number to go up to 400 or down to 200, say someday?
From council perspective, honestly, I think the reason it's just 300 is largely been a creation of the board. Historically, the board, not this iteration of the board, but prior compositions have made it kind of directly clear that 300% was their preferred A group or their preferred risk compensation penalty. I've requested higher in the past and been rejected each time. So I think that the truth of the matter is I think it's a comfortable percent the board's kind of come to terms with in most operators. I think I know for some operators in their JOAs, they put 400%. So I think 300% is certainly not a preference, but I get the impression that it's kind of board driven.
Okay, good point. Okay, that's all the questions I have for this witness. We'll turn the time over to the division for their presentation.
Thank you. Yeah, the division, we reviewed the request made by OVINTIV in this matter. We reviewed the exhibits. We also reviewed the declarations of Mr. Allison and Mr. Hall based on the comments and testimony made here today. The division is supporting this request.
Thank you. I was going to take some time for closing statements from the division, but that pretty much what you say right there is what you believe. Okay, we'll go with that. Mr. Mayo, do you have closing statements?
Sorry, I was coordinating with the witness. No, my closing statement would simply be thanks for setting this up and taking the time today. I know this process is a little wonky at times, but it's great opportunities to have these conversations a little more informally, and we appreciate the time and effort that was submitted.
Thank you. Well, at this time, I'd like to go off the record and take a few minutes to deliberate with my counsel if I can.
Sure.
Bring us back on live.
You're live.
Thank you. Thank you. Mr. Mayo, would you like to move forward with your admission of exhibits at this time?
Yeah, that would be fantastic. I appreciate the reminder. At this point in time, I'd like to move forward the list of exhibits 1 through 22 and remind everyone that the declarations used here today were filed as numbered exhibits, so they're included in that. So I'd like to move for admission of exhibits 1 through 22.
So admitted. Having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find OVINTIV has provided sufficient notice of opportunity for non-consenting CP owners and those owners identified in the request for agency action. Okay. Sorry here. So at this time, let me just grab something here. I'm sorry. So I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present in these wells, and find that it would be appropriate to impose that requested non-consent penalty. I find OVINTIV has met its burden of proof to show that they are entitled to forced pooling of the named interest and other relief requested in the request for agency action. Mr. Mayo, will you prepare an proposed order? I then will present the findings and conclusions to the board next week at the board hearing.
2 weeks.
Oh, 2 weeks, I'm sorry.
2 weeks.
Any other comments before we close? If there are no other comments or issues, we thank you for your participation and we will adjourn this proceeding.
Thank you. Ash, you're done. Check out Chris. Stick around for one more if you would.
All right. Thank you all. I appreciate your help.
Thanks.
Yeah.
Okay. Move on to the 132.45. Does anyone need a break here or are we good to go?
Just a minute to get everything.
Okay.
I just restroom then.
Okay.
So are we on break?
We're on break. Yeah, I'm gonna go ahead and mute the microphone during our break. Okay, we're back on. Armin, we good to go?
We're ready when you are.
Thank you.
Okay, thank you. Good morning, everyone, and welcome. My name is John Rogers. I'm an environmental manager with the Division of Oil, Gas, and Mining, and I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. Today is Wednesday, July 17, 2024, and this is the time and place for the hearing examiner proceeding for docket number 2024-038, cause number 132-45. In the matter of the request for agency action, OVINTIV USA Incorporated for order pooling interest, including the compulsory pooling of the interests of certain non-consenting owners in the Fitzgerald, Utah 9-35, 4-2-1-12-7H well in a drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Formation, comprised of all sections 1 and 12, Township 4 South, Range 2 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. We will also be hearing testimony and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank the division staff, legal counsel, petitioners, and the department technical staff for allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public responsive present and wish to comment on these proceedings? I see none in the room, but again, do we have,
We are up and live on.
since we're online, we have no one there. And Julianne, did anyone want to contact us on this matter? Okay, thank you. Let the record show no public respondents are present. We'll take appearance at council at this time.
Thank you, Mr. Rogers. Mitch Mayo, Blair and Lair PLC on behalf of petitioner of OVINTIV USA.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
My counsel, Gary White of the Attorney General's Office. I have received declarations from Mr. David Dale, the manager of Rockies Land for OVINTIV, and Mr. Christopher Wall, a senior reservoir engineer for OVINTIV in this matter. I have reviewed them before this hearing. Mr. Dale has not appeared before this board before as an expert witness. I've reviewed his resume beforehand. However, Mr. Dale, could you present a short summary of your experience, particularly in the Uinta basins for those?
Yes, in 2007, I graduated from the University of Oklahoma with a degree in energy management. Immediately following, I worked as a landman for Samson Resources, Apache, and Newfield, which of course became OVINTIV. In those roles as a landman, I focused primarily on acquisition of leasehold, managing third-party brokers, reviewing and curing title, and then drafting and negotiating common legal agreements used in the oil and gas industry. Within the last 3 years, I've assumed the role of manager for the Rockies land team, focusing primarily in Utah and a little bit in North Dakota. And within that role, I manage our landmen that testify before you more commonly.
Okay, thank you. Does the division have any objections to these declarations or these individuals being qualified as expert witnesses?
I do have more questions for Mr. Dale. Could you just explain to me kind of on a day-to-day basis what your current role involves?
Yeah, I mean, it changes often, but yes, no, we, similar to what a landman would do, then my primary function would be to really ensure that our team is following the priorities of the broader organization. I attend an awful lot of meetings, which I try to spare the rest of the team, and then gather the information and disseminate it down. And then, of course, in matters like this, if we are low on bandwidth, I'll jump in and handle some of the work that the landman would typically take on.
I noticed in your resume, you've been, I'm assuming this depends on company. You've had different roles as landman, senior landman, landman 3. Do any of these roles require any additional certification outside of your original degree in energy management?
They do not. They do not require an advanced, like a JD. Oftentimes people will get a certified professional landman certification, which is somewhat similar, I guess, to keeping up with your continuing education credits as a JD, but not quite as strenuous.
And how much experience would you say you've had in this current area in the state of Utah?
In Utah, well, from 2018 to 21, I was the manager of our surface operations for Oklahoma, North Dakota, and Utah, which that's acquiring surface use agreements, right-of-ways that we use for electrical, road, pipe. And then the past 3 years, I've worked specifically focusing on the mineral side in Utah.
Okay. One final question. If I was to say to you, boomer, what would be the correct response?
Sooner, of course.
Well, would that the division have more objection?
Is there a conflict of interest there?
I'm a fellow boomer sooner.
What are you gonna do? You can't help it.
All right, thank you. I assume you're okay with the expert witness. Okay. These individuals are recognized as experts in their particular field of study and work for this matter. Since these witnesses are present online, can we swear them in now?
That would be appropriate.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Okay, thank you. We'll now proceed to Mr. Mail for his presentation.
Thank you, Mr. Rogers. I'll try and keep this brief. As noted, Mr. Dale and Mr. Wall will be testifying here today as experts in petroleum land management and petroleum engineering, respectively. Pursuant to board order, they're here testifying remotely, but subject also to cross-examination of declarations that they filed last week. I mentioned briefly, and I'll mention here at the outset beforehand, there is one change to the declaration of Mr. David Dale that's necessitated. We'll explain that in detail, but we'll be supplementing the record after this hearing. The board has jurisdiction and the hearing examiner by designation over this matter pursuant to Utah Code 40-6-6.5. A copy of this request was sent to all parties entitled to notice, including the non-intending CP parties or the parties we're seeking to pool in this hearing. In addition, notice of the filing of the RA in this hearing was duly published in relevant newspapers as required under Utah law. On July 10th, the division expressed non-opposition to this request pending presentation here today. And as was confirmed on the record, there are no other objections or responses to this request here to consider. As Mr. Rogers noted, this request is for the compulsory pooling of a unit covering sections 1 and 12 in 4 South 2 West, a 1,291.08 acre drilling unit established under board order 139-150. OVINTIV is the majority interest owner, significant majority interest owner, as testified to in Mr. Dale's declaration. Pursuant to the orders on file as Exhibit 2 in this cause, OVINTIV spud the Fitzgerald UT 9-35 4-2-1-12-7H well on May 6, 2021, with the first date of production of July 19th, 2021. At the time the RA was filed, there were no wells producing from the subject lands. Accordingly, conversion is provided for in the 139-150 order is not applicable. I'd like to note some notifications that were present and some additional modifications coming. There were 4 parties named to be pooled. Only one of those parties remains to be pooled, along with the decedents and the unknowns. That party is Curtis Abiglin and Christine Lee Abiglin as joint tenants. The other 3 parties named have been removed for various reasons. First, Ms. Colleen M. Ramirez leased her interest to OVINTIV. In addition, Phoenix Capital Group Holdings, LLC, was named simply for imposition of a JOA. They have since returned to JOA, signed and executed. And those 2 changes are included in Mr. Dale's declaration on file. Yesterday, we received notice from International Petroleum LLC that they had returned their executed JOA as well. And so we're going to be supplementing the record with a follow-up declaration of Mr. Dale to address that. But IP is no longer subject to pooling.
So they are participating.
They did participate. We were pooling them solely to have the board impose a JOA because they hadn't signed one. So yes, that is true. They are participating and voluntarily committed to the unit.
Now, just let me ask this, if they did not return a JOA, would they be forced pulled as a non-working interest owner, or how would?
Well, so their interest is still pooled and treated as though it's participating, right? They've signed an AFE, they've agreed to participate. So they will be responsible for the share of costs that are attributable to their leasehold interest they operate. But as far as how do we deal with the accounting and how do we deal with notice to each other, and those kinds of things, the JOA lays out the basics of how you operate the well. And so the board allows you to impose that. So what this is basically impose the terms that kind of govern our relationship with each other, so we both know what to expect. But other than that, they would be participating, and I don't know if that clarified or made it.
Oh, so they accepted the JOA you proposed, or was it altered?
My understanding is and Mr. Dale can hit on this a little bit in his testimony when we get to that, but my understanding is IP is now, there's been an understanding between OVINTIV and International Petroleum about the terms of the JOA, and those JOAs have been being executed regularly now. I think this JOA not being signed was maybe an oversight or something that the parties didn't address yet. But Mr. Dale can kind of talk about that.
Okay, I'll bring
in his
that up.
testimony. Yeah. There's also, as we said, decedents that are named out of an abundance of caution for any parties under them who are not leased or committed to this unit. Finally, as reflected on Exhibit 14, the acreage rated royalty to impose in this hearing is just shy of 19%, 18.87059203. With that, I'd like to begin quickly with Mr. Dale's introduction and testimony, and then we have those questions come back.
Okay.
Mr. Dale, can you hear me?
Yes.
Okay. Would you please state your name and business address for the record?
Yes, David Dale with a business address of 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
Okay, and I'd like to remind everyone, Mr. Dale is the manager of Rocky's Land with responsibility over this drilling unit, and he was recently admitted as an expert in petroleum land management of this cause. And his declaration will be viewed accordingly. Mr. Dale, I'd like to have you look at your declaration or talk about it if you could. Do you recognize what's been filed as declaration of David Dale in this cause?
I do.
Did you execute it or cause your counsel to execute it on your behalf?
I did.
Are you familiar with all the allegations contained in that declaration?
Yes.
And I'm assuming you heard my my explanation about International Petroleum returning a JOA yesterday. Subject to that clarification that will be made later, does the declaration that's on file accurately reflect your full and complete testimony in this cause?
Yes.
Is there anything else you'd like to add before I turn you over to the questioning division and hearing examiner?
No.
Okay. Thank you.
Okay, division.
You, Mr. Dale, just again, more a questions, just general questions about your testimony. We talked about Colleen Ramirez is now leased. Would you be able to speak on how that happened after the fact? We just like to know, when these people get noticed, how do you end up leasing them?
Yeah, oftentimes parties receiving mail may not be informed on the oil and gas industry and particularly the forced pooling proceeding. And they may not be timely in responding to mail in general. So in a lot of cases, people get the mail, they put it off, they don't know what to do with it. Enough time elapses, they have a 30-day election period, and sometime between then and actually having a hearing, they get to calling our brokers or calling OVINTIV, inquiring what it's about, and we discuss the matter of release, and we come to terms and decide that's the best path forward. In that case, I guess it could be stated, we could move forward and just simply force pool them, but it's much easier at that point for all parties just to lease them and let them be a passive investor on the royalty side.
Okay, thank you. And then Phoenix Capital Holding, were they just taking longer than needed to sign a JOA, or did you negotiate new terms?
Yeah, with some of these parties, they will elect to participate but not return and execute a joint operating agreement. With Phoenix, they just signed what we sent to them as JOA. Why they were delayed, I can't speak, but we do have an executed JOA in hand and good to move forward.
Okay. And then we brought up IPLLC. Well, I did have questions about that, but I guess now that they're signed, we don't need those anymore. So, I have no further questions for today.
Thank you, Mr. Haynes. I looked through here and there are no unlocatables here. Is that correct?
That's correct.
No named unlocables. There's any decedents
Yeah.
that we don't know about.
That
Yes,
one,
that's right.
okay, so
That's right.
that's not an issue. And, you know, I did have some of the same questions concerning Phoenix and International, and I just want to get some clarification. So in here you say, although OVINTIV anticipates IP and Phoenix will execute a JOA, until they do, they'll be pulled solely to impose a JOA. So does that mean you would not take them in as a working interest partner without a JOA? That's your contract to do business, correct?
Yes.
But how could you manage that if you didn't have a signed JOA?
We need a joint operating agreement in place because it dictates elections, how they pay their cost share, right? And how we pay revenue. It also requires them to take liability on any future plugging and abandonment operation. You know, absent a contract in place, we have no legal mechanism to force them to pay their bills when they're due. And so we would still proceed forward with the forced pooling. But you're right, it is a gray area. They've elected to participate, but under what legal contract?
Well, that's my concern here is, I mean, obviously it's taken care of, but just to clarify things. If they had come today and said, we're not signing a JOA, and they were in this room and said, this is where we're going, then I'm assuming that we'd have to take that before the board and have that forced upon them.
We would have to, and the board's done it in several hearings before. So yeah, that's exactly what would happen in this hearing examining process.
So being that the JOA was signed, do they negotiate terms different than other JOAs, or are they all the same? You say, this is the one we're taking, take this or nothing.
I mean, obviously that's probably more a question for Mr. Dale, but I would say the answer is most likely it depends, right? Some one-off mineral owners that have 1 acre in 1 unit don't have a lot of negotiating leverage if they want to change the terms of the JOA. But if Phoenix owns 5 acres in 10 different units, you know, maybe OVINTIV wants to, or maybe there's more incentive to negotiate a JOA that's agreeable to both sides. And maybe you can say it a little more artfully than I did.
No, I think that's right. Typically the JOA form that we send out is a standard form that's commonly accepted within the industry. For parties that are small and how do I want to say this? I say unsophisticated. This is not their typical line of work, and they are not experts in legal contracts. They will oftentimes sign that JOA, and a lot of parties who are experts will sign that JOA. Now you will reach parties who, as Mitch alluded to, they have interest not in this unit, but multiple units, and they are experts in this field. And there's a provision or two within the JOA that they just feel like needs to be addressed, and at which point we'll negotiate, and oftentimes we'll come to an accommodation for them. And once we have that contract in place, and this is the case with International Petroleum, this was a contract that was hammered out a year or 2 ago. And once we've come to an understanding, we'll use that form with that party moving forward.
Okay.
But they are essentially there are very few modifications to the difference between the forms.
My concern is that these individuals or these companies use this hearing examiner or the board not to sign it and just try to get a better deal. And I don't know if we've seen that happen, but it's a concern I have.
We've seen that happen, you know, at least once that I can think of where, you know, essentially that has happened successfully. And I think the truth of the matter is, you know, there is a difference, you know, when we talk about sophistication or parties with more leverage, what we're really talking about is these are incredibly complicated legal contracts. Even for the people in this room who understand oil and gas, they're incredibly complicated and dense. And so my mother-in-law, let's say, has a 1 acre out in the basin. If she wants to participate, she's gonna have a hard time even understanding what the contract means, let alone how to negotiate terms that make sense for her in a way. So the truth is, it's only really savvy parties that are going to object to the JOA. And they're gonna do it in a way that's designed to get the board in a position that they feel is
Okay, well, I have some questions about that, but ever since they've been signed and on, we'll just move on from there. So I have no more questions.
Can I just add a comment to that?
Sure.
I guess the concept of non-consent penalty was addressed in the prior hearing. And I guess one thing to add here is I have not seen a JOA negotiated where that non-consent penalty has been a point of contest. In fact, in my experience, the majority of the JOAs that I see are higher than 300%. That is the minimum threshold. And the reason for that is this industry is incredibly capital intensive and incredibly risky. Beyond just the drilling operation, you have labor costs, steel costs, you have commodity prices, and then as we see today, you have marketing capacity, which can prohibit you from selling your product and receiving revenue. So it is my expert opinion that a minimum of 300% is a more than fair non-consent penalty.
Thank you. Just at a very high level general question, when you're negotiating a JOA, what are the major issues? I assume penalty may be one. What are other issues that are brought to light?
Yeah, oftentimes we'll want to talk about when invoices are due. So when in all these wells, we pay the money up front and then we bill our parties to recoup what they owe us their share. And there's a lot of contesting on how quickly they have to elect, what their audit rights are, how the notification works. And that people oftentimes want more time. And as an operator, what we've seen is that taken advantage of, and they ultimately will not pay their bills. And so we have to have some enforcement that if you're going to elect to participate and these invoices are fair and true, and you cannot dispute them, then you'll pay or you'll be out and we'll recoup interest against you. And that's oftentimes one of the most contested.
Okay. All right. Thank you, Mr. Bell.
Welcome.
I have no more questions.
Okay. With that, David, stick around. You can put yourself on mute. You may be asked follow-up, but you're done for now, if that's all right. Thank you. Chris, are you around still? And can you hear me still?
I can hear you.
Hey.
Him up instead of Ashley.
Perfect. Chris, we've been through this once before today, but I'm going to go through it quickly again if you could. State your name and spell your last name for the record, please.
Sure. Christopher Wall, W-O-L-L, business address of 4. Okay.
Yeah, I think we're all sick of hearing the business address. I don't know why
Okay.
we asked it, so I'm saving you. If anyone here objects, let me know.
That's critical.
It's critical. It's the missing piece. I'll find out that I was wrong legally and correct that at some point, but I don't know. And I'd like to remind everyone, Mr. Wall is recognized as an expert in petroleum engineering for purposes of this cause and for consideration of this declaration. Mr. Wall, I'd like to have you confirm your declaration testimony quickly. Do you recognize what's been filed as declaration, Christopher Wall, in this process?
Yes.
Did you execute or cause that to be executed by counsel on your behalf?
Yes.
Are you familiar with all the allegations in the declaration?
Yes.
Okay. And does the declaration, well, before I ask this question, I'm going to ask a couple random questions about one of the exhibits. There's a slight modification to one of the exhibits that we wanted to mention here on the record. I believe it's exhibit 18, but it could be 17. I'm going to double check 17. Do you want to briefly talk about that correction in regards to the risk as well?
Yeah, so there is an error on that exhibit, and it has to do with the very last line there. It incorrectly stated that the casing was set 475 feet short, which is incorrect. The casing was set to TD on this particular well.
Okay. And is it fair to assume that that mistake, if you will, was a fat finger copy by counsel, maybe in preparing exhibits for these hearings? It looks as though it was pulled from verbatim from the hearing that we just had a few minutes ago.
That appears to be the case, yes.
Okay, I apologize for that. If it's okay with division and hearing examiner, we'll correct that exhibit after this. Mr. Wall, with that clarification out of the way, does the declaration as conformed to the testimony and the corrected exhibit 17 discussed here today, does that represent your full and accurate testimony in this cause?
Yes.
Is there anything you'd like to add before I turn you over to the hearing examiner and division?
No.
With that, I'm done with Mr. Wall, subject to cross-examination.
Thank you. Thanks. The other division has no questions for Mr. Wall.
Okay, well, with the testimony earlier concerning the 300% was very enlightening. Thank you to Mr. Dale. I also had questions on exhibit 17 and taking my thunder away there. So,
Sorry about that.
I was wondering why that was the exact same distance.
Yes,
So,
as was I.
okay. Well, anyway, I really had no more questions for Mr. Wall on the engineering perspective.
It might be, I guess, appropriate then to move for admission of exhibits 1 through 21. Clarifying, however, that exhibit 17 will be corrected exhibit 17 filed shortly after this hearing today. And we will also be filing a supplemental declaration of David Dale to address that. That's exhibit 18. So I will move towards admission of exhibits 1 through 16, corrected exhibit 17, supplemented exhibit 18, and exhibits 19 through 21. Okay, with that, I'd just like to remind everyone that notice was provided to all those parties. Clearly, that notice was effective. 3 of those parties responded, and complied. The one party who has not is still subject to pooling, but the pooling has been proven, I believe, based on the allegations. And with that, I'd just like to thank everyone here for their time and attention and submit.
Did I ask you for your presentation or?
No,
Okay, do that now.
let you know right now.
Sorry.
Oh, you're good. Yeah, once again, the division reviewed this request, associated exhibits. We reviewed the declarations by Mr. Dale and Mr. Wall. And subject to the amendments that were discussed here today of the exhibits and the declarations, the division is in support of this request.
Thank you. Mr. Mayo, do you have any closing statements you'd like to make?
No, because I got the cart for the horse and I made them already.
Okay, I just.
Thank you.
That's no problem. Yeah, I'd like to take a few minutes with my counsel, so we'll go off the record for.
Okay, off the record.
Armin, we're back.
You're live.
Thank you.
Thank you. Mitch, we already admitted the exhibits, correct?
We did.
Okay. Okay, having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find OVINTIV has provided sufficient notice of opportunity to the non-consenting owners that these owners identified in their request for agency action did not timely elect to participate in the well and therefore should be deemed non-consenting party. I find that a 300% non-consent penalty is fair and justified given the economic and geological conditions present with these wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that they are entitled to forfeit on named interest and other relief requested in their request for agency action. Mr. Mayor, will you prepare the proposed order?
I'm happy to do that.
Okay. I will then present these findings and conclusions to the board in 2 weeks at the board hearing. Any other comments before we close? Okay, well, thank you for your participation. Thank you for being online, and we will adjourn this proceeding right now. Thanks.
Thank you very much. Thanks, guys.
Thank you.